Secretary of State.
Yes, good morning.
Good morning.
Before you start, can I just indicate that obviously we've read the papers and we have, I think, a lively appreciation of the issues. So at the moment, we're confident between you, you'll have finished well before lunch.
We anticipate that to be the case.
Yeah. So with that in mind, and do I say Gaja?
Gaja, my lord.
Gaja.
Thank you.
Then over to you.
My lord, I'm grateful. Just by way of housekeeping, Mr Stedman and I appear on behalf of the appellant. Mr Malik appears on behalf of the Home Secretary. In terms of housekeeping, an apology from myself, the bundle that was provided, the core bundle by the appellant, does not contain the skeleton argument that was relied upon in seeking permission to appear. I hope that the court has received it, and again echoing my apologies on that point. And the final apology is in respect of the authorities bundle. There was an email sent out.
Before you get to the authorities bundle, we don't have the order of Mrs Justice Stacey granting permission. It might be quite interesting to see that. And the order of the Deputy High Court Judge says that permission was refused, but the claim was dismissed rather than permission being refused, wasn't it?
My lord, that's right. In terms of Mrs Justice Stacey, hopefully the court should have her order at page 111.
I missed that then.
Yes, we do.
Oh yes, no, I have missed that. I'm so sorry. I was looking for that. So she did grant permission. So the order of Mr Clayton, where's that gone now? That's page 40. It says the application for permission is dismissed, but it's actually the claim is dismissed.
It's the substantive claim, that's right, my lord.
Yeah, thank you.
Just we were obviously discussing the case before we came into court. Just one point, small point, has had no effect on this case, but it's usually best for us to be given a bundle of documents which does not contain underlinings and comments. These documents do, I mean, it's best that we have a bundle that's completely clean.
My lord, I entirely appreciate that. I assume that references to the historic witness statements from 2007 and 2010. Without wishing to apportion blame in any way, those documents were served with the respondent's detailed grounds of defence. I assume that it may be difficult to find clean copies of those, so apologies on behalf of both parties, I think I can safely say.
Yeah, as I say, it hasn't made any difference in this case, but it's usually the best thing. Okay.
My lord, I'm grateful, and just as a final point of housekeeping, the authorities bundle that the court has will not have a very recent authority that the court may be aware of, which is the decision of Hugh Mercer QC in the case of AHN. With your leave, if I can perhaps just hand out copies of that, it's one paragraph, paragraph 29, that the appellant would seek to rely on. Thank you very much.
What is the concession referred to? Paragraph 29?
My lady, I confess I'm not sure that's correct in terms of a concession. It may well be that the Deputy High Court Judge in that case was in fact referring to an argument or a submission that's made. Having read the judgment in the round, I can't seem to identify any concession by either side. Although, as the court may have seen, this was accepted by both parties to be a potentially academic claim, in the sense that the respondent had agreed to reconsider. Nonetheless, the High Court decided that the principles were of such a wide nature that the court should proceed to hear the matter in any event.
So I'm just trying to admit it in advance. I'm just having difficulty reading the English. A major criticism advanced is the failure of the defendant to give any or any sufficient weight to 20 years of concern-free residence, in addition to the 5 years before that. And in my judgment, this is a wise concession.
I think what you're saying is delete that sentence because it doesn't make any sense.
I say that with some caution. I am making assumptions that that is wrong, but it's not entirely clear what concessions may have been offered.
Or whether he's saying that it's a relevant factor, but everyone knows it's a relevant factor. The question is whether the passage of time is sufficient for the Secretary of State to disregard the earlier concerns.
My Lords, I'm grateful. So with that in mind, if I may proceed to my submission.
Yeah.
I'm grateful. In essence, just to provide a roadmap in terms of the appellant's submissions, the headline point is, of course, Lord Justice Mayles confirmed in his grant of permission that the Secretary of State was entitled to reach a conclusion that the appellant had, by fact, had associations with extremist individuals. And so there's no argument on that point. The question is whether the refusal of naturalisation in this case, and subsequently the decision to uphold that by Judge Clayton, was indeed a rational and lawful decision. What I intend to do with that in mind is to provide the court with a very brief whistle-stop tour of the law in this area. Of course, the authorities at the court will have had the opportunity to read, I hope, does provide a breakdown of the issue in this area, and there isn't, in reality, a dispute insofar as the law is concerned between the appellant and the Home Secretary. And then I'll move on as briefly as I can to the substantive submissions in this case. So, dealing, my Lords, with the law in this area, and focusing to begin with on my submissions with the authorities bundle, as the court will undoubtedly be aware, the decision to grant or refuse naturalisation is governed by Section 6 of the 1981 Act. And the language can be found, the statutory language can be found at page 3 of the authorities bundle.
Yeah.
Now, it is, of course, as clear as day that the Secretary of State has a wide discretion. If the requirements of the rule or the statute are met, it is ultimately still only if the Secretary of State thinks fit that naturalisation...
Well, it's more than that. She's got to be satisfied that the applicant meets the criteria. He must produce evidence that he satisfies the criteria, otherwise she can't be satisfied. It's not she must show he doesn't, he must show he does.
Absolutely, my Lord, and to that extent, as I say, there's no dispute insofar as the burden is concerned in satisfying the statutory requirements. Now, again, as the court will be aware, and hence the whistle-stop tour, if we turn the page to page 4, we have Schedule 1 of the 1981 Act. And at subparagraph 1b, one of the requirements that the appellant must demonstrate he meets is that he is of good character. Now, the emphasis on the word is in my submission, key in this case, because it demonstrates that it is an assessment of the appellant's character in present day. And as you have seen from my skeleton argument, my lords, there is no dispute that character has to be assessed holistically, and that will involve an assessment of historic associations, historic behaviour, historic events, and everything has to be thrown into the mix. But the ultimate conclusion has to be about one's character in present tense, not what it may have been 20 years ago, 15 years ago, whatever the range may be. Now, the authorities in this area, and they are plenty, identify the wide discretion that the Secretary of State enjoys, and they, of course, provide caution to judges dealing with applications for judicial review challenging refusals in this nature. The first of those authorities is the case of Al-Fayed. Al-Fayed, of course, is an interesting case in the sense that it was, of course, allegations made against the claimant's character in that case on the grounds that he had overseen but not stopped the theft from a safety deposit box in Harrods from belonging to Mr Tiny Rowland, and the other allegation being the payments that were made to members of Parliament in order for questions to be tabled. That case and the particular paragraph summarised by my learned friend in his skeleton argument can be found in the authorities bundle at page 27, and although faint, and forgive me for that, the relevant paragraph has been highlighted. Again, we have no issue in terms of a dispute on the law as to the discretion the Secretary of State enjoys and the caution that judges should employ when reviewing such decisions.
We've read the authorities, so
I'm
you
grateful.
can go slightly faster.
I'm grateful, my lord. Well, the matter is then echoed in the case of DA Iraq, a case, I believe it was Mrs Justice Lang at the time, at paragraph 59, which you'll find at page 59. That again highlights the high threshold that an individual has to meet before they can successfully challenge a decision to refuse naturalisation.
And in your case, is it that the Secretary of State, that no rational decision maker could have reached the conclusion that was reached here? That's your position. All right, thank you.
Now, given my Lord's indication of the authorities, I'll then very briefly move on to the final key authority that my learned friend refers to in his skeleton argument, the case of the Secretary of State and SK, which echoes what my Lord Justice Lewis said at the beginning of the hearing of the subjective element of the test that has to be applied, and again simply repeats the position in terms of the burden of proof. So that, my Lord, will find for your record and for your notes at page 134, paragraph 31 of the Court of Appeal's judgment. Now, with those authorities in mind, the appellant is alive to the fact that the spectrum of decisions that the Secretary of State can reach with reference to Lord Justice Norse's judgment in Al Fayed is a wide spectrum. And if that spectrum is drawn on a line, the appellant's position would be that this decision, or the cumulative decisions that are made by the Secretary of State, fall short of being a reasonable decision. Very briefly then, if I may, to just move on to the Secretary of State's guidance on good character, and starting off with page 162 of the authorities bundle.
Just before we go to the guidance, is this right? None of the authorities reveal a case in which the challenge was successful.
AHN would be the successful challenge. The authority.
Sorry, say again?
My Lord, AHN, the most recent authority of the 16th of
Well, they'd
March.
agreed to review the decision.
Indeed.
So that doesn't count.
Well, I think...
I mean, it was entirely academic because the Secretary of State had agreed that decision would be reviewed.
My Lord, whilst I accept that point, that the Secretary of State had treated it, had put forward and tabled a consent order, looking at paragraph 51 of the High Court judgment, the court proceeded to grant a declaration,
Yeah.
and the appellant, the claimant, forgive me, was successful insofar as costs were concerned. So there was a substantive success.
Yeah, but was it a success on this man should have got citizenship and he didn't, or was it a success in the sense that the Secretary of State should have considered certain factors and she didn't?
My Lord, the latter.
It's the latter, really, yes.
Yes. And in reality, I'm not asking you to go beyond that.
Yeah.
Sorry, so your case is that there was a failure to have regard to factors, rather than had regard and reached a rational decision.
I think it's both, but because
Yeah,
they collide together.
Yes,
into
I
the
think
The
same-
that's
first
fine.
ground is that you fail to have regard, the Secretary failed to have regard to relevant factors or give adequate reasons. The second ground is reaching an irrational conclusion and misapply the guidance. And the third ground is the judge himself didn't give clear reasons. That's what I understood the 3 reasons to be. It would have been helpful if you'd have rather better grounds and not just annexed the amended claim form, but still, there it is.
My Lord, yes,
Those are the 3 grounds, in effect.
the grounds of appeal, which I didn't author,
I know you
indeed
didn't
somewhat
authorise them.
convoluted, but ultimately, I think, as both my learned friend and Lord Justice Mayles in granting permission, I identified, and the appellant would accept, there is a significant overlap in terms of the reasons, and so I intend to merge the submissions into
Yeah, but if you look at page 27, the grounds of appeal and what you've actually got permission on is grounds 1 and 2 of the claim form, and what you're effectively I think you're saying is that the judge was wrong to dismiss grounds 1 and grounds 2, and then you go on to paragraph 3 to say there's a failure on the part of the judge to give adequate reasons. So I'd worked out that there were 3 grounds of review, of appeal.
My Lord, yes, of course, given that this is an appeal against the Deputy High Court Judge's decision,
Yeah.
one must, of course, attack
Well, you must be saying that he was wrong to dismiss ground 1 and he was wrong to dismiss ground 2, and he doesn't explain why he did it. And in reality, on the facts of this case, you're rerunning the JR in reality.
Yes, my Lord, I do accept that.
All right, so you wanted just to look at the guidance.
My Lord, yes, and just as a refresher, it's
Page.
162, if I may.
Yeah. Yeah.
And 162, my Lord, just under the subheading approach, identifies and really chimes with what the authorities say about the width of the Secretary of State's discretion. So the statute does not provide a definition for good character, which we are, of course, aware of. The paragraph beneath that is key because it, again, as much as plain as night follows day, indicates that an assessment of one's character must include a consideration of all aspects. So that is the starting point insofar as the guidance is concerned. For nothing but the sake of completeness, and I may come back to this later on in my submissions, the key element of the guidance dealing with the question of associations with individuals involved in terrorism or extremism can be found at page 186 and flowing on to 187. And that lists some of the non-exhaustive factors that the Secretary of State says that she is entitled to have regard to. When
Which page you...
186.
Oh, 186, is this? Sorry, I thought you said 176. My fault. Yeah. Oh, yes, the association. Yeah.
Yeah.
Now, my lords, that deals with, as I say, the whistle-stop tour, and it brings that tour to an end insofar as the law in this area is concerned. With that in mind, to again go back to my roadmap as to where the appellant is going, there are 3 key areas where the appellant says that both the Secretary of State and subsequently the decision of the High Court have reached an irrational conclusion. And the focus will be, firstly, the passage of time, then moving on to the appellant's current family life, which has subsisted and evolved since 2011, and finally, the detail as to the alleged associations and what the appellant would say is the lack of any extremist views on his part.
But she's inferred those from the fact that for many, many years, his family and Mullar Krekar's family were close friends. He married into that family. He was the son-in-law of the man who was the extremist group leader. He wanted to remain in the family. And she infers from that he had, in fact, similar views. And then he mixed with other people in London who also had extremist views. And she's inferred from that at that stage you can take the approach that he is not distancing himself or sharing those views, and that's what she said. He hasn't demonstrated against that background that he doesn't share the views of the people that he's associating with.
Well,
I mean, you're not quite challenging that finding, as I understand it, are you?
This case has evolved, and I did intend to come to that towards the tail end of my submissions. This case has evolved in terms of the Secretary of State's reasoning. The earlier two refusal letters, so the 2019 and 2020 refusals, appear to limit themselves to the appellant associating with individuals who have extremist views. The 2021 supplementary refusal letter, which comes into play, of course, after these proceedings were initiated, begins to allege, and the appellant would say without any reference to sources to support the position, that somehow the appellant also held these views. But the appellant's evidence, and I'll take you to that when I come back to this point in substance, my lord, is that he's never held these views. And he's expressed that before the Secretary of State in clear terms.
But it's a separate question. He says he doesn't have those views. In the January decision, the reason is his association with known members of Ansar Al Islam and his relationship with Mullar Krekar and the fact that he was going to visit him there. And she goes on to say, you continued with these associations. You provided no evidence to suggest you were seeking to counter or moderate their extremist views. And later on, she makes it clear that there's no evidence to suggest that he didn't share those views. And this is a relationship of many years with Mullar Krekar and a relationship with others. So I just need to be absolutely clear whether you are saying that the Secretary of State could not rationally come to the conclusion that she wasn't satisfied that he didn't share those views.
Yes, precisely. That is the appellant's case, my lord. And as I say, there are
So
three
it's
facts.
evolution all round, because that I'd say that was not clear to me from any of the documents. Anyway, you make your submissions in the order that you have just outlined. That's fine, but you can tell from the questions of the court that it is the third matter on which considerable significance may turn.
My lord, I'm grateful. Well, dealing then with the first of the issues, so this is the passage of time. And just for a second, going back to the case of AHN, it is accepted, and just looking at paragraph 29 and what the Mullar QC recorded as the law in that area, there is a reference by the High Court to Mr Justice Sales, as he then was, in the case of Thamvi, where it was identified that there may be some cases where conduct is of such a serious nature that one is simply excluded from ever being hopeful of naturalising as a British citizen. And that, again, is not something that the appellant is here to dispute or to argue before this court. The position that's taken in this case, and this is an out-and-out rationality challenge against the Secretary of State's decision, is that given the time that had passed, which, as he outlines in his witness statement, was a period of between 14 and 15 years since he's had any form of contact, either with Mullar Krekar or the individuals that he was living with in the property in London, the Secretary of State's position is untenable. Now, the guidance, as I say, probably rather sensibly, doesn't provide a timescale that is required before an association.
How could it provide a timescale? I mean, that would be absurd.
Absolutely, and that's why.
So how is it untenable if there's no timescale? Doesn't it always turn on the facts?
Well, precisely, my lord, and this is why, at the end of my submissions, I'll invite the court to find that the passage of time and what's happened in the passage of time, which will include my second point about the appellant's current family life, when all of that is taken into the round.
That's saying we should take a different decision with the Secretary of State. If you look at the letter, what she said is, for a long time, you wanted to be the son-in-law of the man who heads this terrorist group. You were mixing with people who had extremist views. Yes, 14 years have passed, but there's nothing to show those associations stopped because of a change of heart on your part. The Krekar family relationships broke down when the marriage broke down. The absence of contact with the five individuals may be the result of the control order. The Secretary of State isn't satisfied that he would have stopped mixing with those people out of his own free choice. There's nothing to show that the views that the Secretary believed he had at the time have changed, and she would normally expect more time to have passed to disregard those matters. So you've got a situation where he's got a show of good character. The evidence shows a long period of close associationship with the family headed by the man who's the head of the organisation, and subsequent mixing. And she says, I'm not satisfied that that would have stopped, and you haven't satisfied me that your views have changed. How can that be irrational?
Well, my lord, I think if we unpack that question, the long period that the court refers to has to be seen with a degree of context, because the witness statements that have been proffered by the appellant do confirm that since the 1970s, the Krekar family and the appellant's family have known each other in one way or another. We are not, of course, assessing the appellant's family's good character. And I say that because the appellant was born in 1978. And so a significant period of what could otherwise be termed as a prolonged association or connection between the two families is likely to be discounted on that basis. Now, if we look at Mullar Krekar alone, the key point is we have known contact at some point in 2004. We then have the marriage, which lasted the best part of 3 months.
You've got families who are interlinked for decades. You've got Mr. Amin's brother marrying Mullar Krekar's sister, I think. In 2004, Mr. Amin contacts Mr. Mullar Krekar, not the other way around, and says, I'm coming to Sweden. And Mullar Krekar says, come to visit us in Norway. Then there's the marriage. Then there's repeated attempts by Mr. Amin to remain part of the family by refusing the marriage, seeking advice on invalidating it. And the Secretary of State says, well, hold on, I think you wanted to stay a part of this family headed by the terrorist leader. And therefore, I'm worried about that. And you haven't shown me that you are not of the same view. All you've shown me is you can't associate with the Krekar family anymore because the marriage is broken up and you don't associate with the other people because of the control order and you're worried about your immigration status. Those are the views that she's got, and what you've got to, that's what she says in the letter, and what you've got to attack, I think, is to say that that's irrational.
Well, yes, and this strays into my second submission, which comes into the question of present day.
So on the timing, at any rate, you say, well, it's 14, 15 years ago, and so you say, although there's no time limit in the guidance, and you accept it always turns on the facts, so you say what? That the 14, 15 years must mean that those associations should be disregarded? I mean, I don't quite understand how you put the time, just on your first point, the time point.
My lord, not as a standalone factor. And of course, as the guidance indicates, there must be a holistic consideration. But we have a 14 or 15 year period of what Hugh Mercer QC in AHN referred to as concern-free living in the United Kingdom. Now, of course, that case was different on its facts because it was 20 to 25 years, but the High Court wasn't.
Not the time,
yes.
It's the circumstance.
Yes.
And it's the concern arose because of the willing association with a family headed by the leader of the terrorist group. And what the Secretary of State says, I know 14 years have passed, but I've got no evidence to make me think that the lack of contact is because you're no longer somebody who has those views. She says effectively at page 78, it's the result of other factors. I'd normally expect a greater period of time, and I've seen nothing to make me think that you've changed your views. That's what she says at 78.
My lord, yes, and I think it is key, again, as I say, to unpack the position of firstly, the family ties have to be taken with care. He's not responsible for the fact his uncle or other members of his family...
No, but the context is a family is associating with another family headed by a terrorist, and he wants to be part of that family. He writes to them and goes to Norway, he marries the daughter, he doesn't want to get divorced from the daughter, and you think to yourself, is there anything to show that his views have changed? He's not mixing with the family anymore. Why is that? Because he's altered his views, or because the relationship is broken down. That's what the Secretary of State is trying to get at. And that's what you need to grapple with.
Yes, and I think, again, when we look at that relationship between the appellant and the Krekar family as a whole, we know from the Secretary of State's guidance that mere association alone is unlikely to be enough. And that must follow as a matter of common sense. It couldn't be the case that any form of association with someone who has extremist views, or as Mullar Krekar was, is involved in extremism, must lead to a conclusion of bad character. And of
It
course,
will depend on the fact.
it does.
None of it is black and white.
Yes.
That's the whole point. It's as you use the word holistic, it's looking at it all in the round. So you can't lay down any rule.
And I'm not inviting the court to do so, my lord. But insofar as the facts are concerned, the relationship with Mullar Krekar, and the Secretary of State has not disputed this at any stage, originates or really continued, not as a result of the appellant's interests in Mullar Krekar's extremist views, but because of a romantic relationship. Now, yes, he pursues the divorce. He contests the validity of the divorce, I think is the proper way of putting it. That's not in itself an extremist view. It is legitimate in any relationship that begins and comes to an end at any stage, whether it's 3 months, 3 years, or 3 decades, for the individual concerned to want an explanation.
But that's not what he said in his evidence. He said, I refused it, I went for 8 days, and it was going to be sorted out. And when it finally happened, I took advice from lawyers and Islamic experts to see if I could overturn it. And one inference you could make is that he wanted to be part of this terrorist family.
Or the other inference is he wanted to continue the marriage that had started.
The Secretary of State's got to decide which it is.
And insofar as prolonging that or not accepting the divorce is concerned, that again has to be seen on the facts and in the context, as my Lord Justice Coulson has said. This is an Islamic marriage, which, unlike the United Kingdom, the appellant's position is a wife cannot unilaterally bring that to an end. Now, that's part of the driving force behind the reason, and my Lord may have seen it from the witness statement that was put forward. The appellant says, well, I ended up taking advice from one of the individuals I was living with who was well versed in Sharia law. We don't yet have any connection that the Secretary of State is able to draw, and this is the gap that prevails.
He doesn't have to prove he's not of good character. No. He has to prove that he is of good character. And from that starting point, you have somebody who has actively known a man who he says he knew was the leader, and he's trying to be in the family. And you're trying to work out, can I safely... the Secretary of State has assumed that that means he shares the views, or at least isn't trying to moderate the views, and the Secretary of State is only saying, can I disregard that now because 14 years have gone? And she says, no, I can't, for these reasons. That's what you've got to grapple with. We aren't the Secretary of State.
No.
We aren't deciding whether or not we think you should have it or shouldn't have it. We're seeing whether her reasons stack up, and you've got to look at page 78, and you've got to say why her reasons are irrational. Not that you would disagree with them, or we would.
My Lord, yes, and as I say, I fully appreciate the narrow target that the appellant has to meet in terms of convincing the court that this decision, all the decisions in question were irrational. And all I would ask, as I appreciate the court in any event will, is for it to maintain an open mind, because there is an inherent connection, given the factual point that my Lord Justice Coulson has reminded me of, between the passage of time and my second submission.
Yeah, I understand it, the two run together.
Yes.
In this holistic exercise that you say the authorities show we must carry out.
Indeed, and if the circumstances were different, if the appellant hadn't established a different family life, if the appellant hadn't moved on in the way that the evidence before the Secretary of State shows that he had, then the passage of time, whether it's 20 years or 30 years or more, may not have gotten him home. But just to tail off my submissions very briefly on the delay point.
So you are on the passage of time point, are you on?
Yes, just finally on the passage of time point, as the court will nonetheless have appreciated. he was 26 years old in 2004 when these connections with Mullar Krekar, and then going on to 27 in 2005 when the relevant issues arose with the individuals that he was living with. By the time he came to apply for naturalisation in 2018, I think it was, by the time he came to apply for naturalisation, he was a month short of his 41st birthday. That, in my submission, is a factor. Again, I'm not suggesting that that alone is enough to undermine the safety of the Secretary of State's decision, but I'd invite the court to treat that as a building block in this case. So we have this situation. What happens then in the 14 or so years, remembering that we are assessing character as a present-day concern, well, date of decision, not date of today's hearing, not looking solely at his historic position? Well, the starting point, and perhaps not my strongest point, so I'll get them out of the way very quickly, is he moves on, he goes to university, and he details this in the substantive bundle in his witness statement at page 153, paragraph 18. This, of course, is documents that the Secretary of State has had and has referred to throughout her decisions.
Yep.
We also then have, just before that, at page 152, at paragraph 17, evidence of what he's trying to do, and he refers to this himself as him trying to rehabilitate. Now, that term is one that was used in the grant of permission by Lord Justice Males. It works in reality, taking the Secretary of State's case at its highest, because in order for one to rehabilitate or be required to rehabilitate, there has to have been some form of adverse conduct, adverse views, and given what's said in the grant of permission about the Secretary of State being entitled to conclude that he was associating with extremists, we'll take it that rehabilitation was required. So he makes reference here.
Well, surely the important thing is he thinks rehabilitation is required. This is his statement.
Yes.
So he thinks that his previous conduct was in some way reprehensible.
I think that paragraph does need to be read in the whole, because my Lord...
I was looking at the bit you showed us.
Absolutely.
I mean, it's his statement, that's the point.
Absolutely, my Lord. But just as a matter of fact, and forgive me for perhaps not taking you through the entire paragraph, given the speed...
I haven't got the paragraph yet. Which paragraph?
It's paragraph 17, my Lord, 152.
Okay.
And you'll see the first line, I do not accept that my conduct has been bad.
So that's fabulously unhelpful, because within 4 lines he contradicts himself. Yeah. I don't accept my conduct's been bad, I need to rehabilitate myself.
Well, yes, of course, we don't have the benefit of live evidence to appreciate precisely what he understood by the meaning of rehabilitate. But this...
Well, playing devil's advocate, you say it could be rehabilitation from being under the control order and having mental health difficulties.
Precisely, my lady, I'm grateful.
But this is 2010, of course. This is what he was saying in 2010.
Yes.
And 2010 was just 3 years after the event. He made an application after that, and that was refused because of his criminal activity, and he was told to try again in 2017. And what is there between 2010 and 2017 and 19, thereabouts, that shows any further attempts of rehabilitation other than he's got married? I mean, where is the positive evidence that he's put forward that he's a changed man?
There is a question that is an unattractive one, given what Lord Justice Stanley Burton said in the case of SK, but it's the rhetorical question of what more could he have done?
Well, that's his problem. He's had these associations, he's got these views, the Secretary of State thinks he needs to show something that says, I've changed. Yes. That's what he needs to do. That's his problem, and that's the burden of proof problem.
Well, the rhetorical question that I'll end my submissions on is, well, what more could he have done? But again, that does
Perhaps you can't do
require-
much more. Perhaps it is a question of waiting for more time.
Um,
But he might want to show certificates or letters from groups that he's worked with, charities that he's worked with. He might want a reference from his employer. He might want a statement from his wife. He might want lots of things. He might want to show books that he's written disavowing extremist views. I've no idea. But all we've got is that statement that comes later when he applies for reconsideration. And even that when he makes one line reference to his wife and children. That's the problem. Secretary of State hasn't got to go out and hunt around. He's got to produce this.
No, my lord, and to a certain extent there will never be a perfect application. There will always be more that one can produce in any form of application that involves immigration decisions, especially of this nature, where there is an assessment and a discretion to be carried out. And of course there's also the risk that he could have written those books, he could have started a website, he could have started preaching, his wife could have provided a witness statement, he could have convinced employers, friends. All of those examples that my lord is
Well, you asked what more could he do rhetorically, and I replied rhetorically. I have no idea what he could do.
Well, my lord, yes, and of course, as I say, that there will always be the option, but there's always the Secretary of State coming back and saying, well, that's self-serving. And to a certain extent, we have that in these refusal letters, where the respondent's position is, you only stopped these associations because...
No, her position is she can't be sure they would have been stopped for his own free will. It's because of the breakdown in the relationship and the marriage. That's the problem. There are other explanations, and she's looking to see if he had turned up and said, I broke links with I divorced my wife, I wanted nothing to do with the Krekars. These were the letters I wrote saying, I want nothing more to do with you, I don't like your views, I don't like what you're saying, I don't want to be associated with those views anymore. I'm exaggerating, but that would have been evidence, but that isn't what happened.
Yes.
What he says is, I merely wanted an explanation for the divorce, when that's not true, because it contradicts his earlier statement. That's the difficulty. You've got to look at the facts. You need to look at the first two witness statements, the one that he made, and the letter, and you've got to show that the letter is wrong. It's not enough to make a case as if it's a public inquiry as to why we should grant it, because we aren't doing that. No. You've got to tackle page 78 and explain where it's wrong. And it's not enough to get home and say it's wrong by saying, well, there are other things or other ways she could look at the same thing. That isn't enough to show irrationality, Mr Krekar.
My lord, yes, and I think I'll
anyway, you know what I've said, so I'll let you get on with your submissions.
My lord, I'm grateful.
You're really on the first one, which you did say, to be fair, was your weakest.
Yes, and the reason, the focus on the family, as I say, just to tail off my position in response to your questions, my lord, is, as I say, one can always do more, and different advisors will advise different things, and the reasons for that can be good-hearted or not. But ultimately, the appellant's position is the evidence that was, and the circumstances that were before the Secretary of State were such that it could not be concluded on a rational view that he is not of good character, or that he hadn't satisfied the Secretary of State that he isn't of good character, that he is of good character, and the emphasis on the is being the present tense. Now, the family life point is, in my submission, key, and it cannot lawfully be underplayed. It represents an entirely new chapter in his life. It is material to this case because it brings to an end the possibility of it rationally being said that at some point in the future he will want to have or to reincarnate his connections with the Krekar family, which bear their origins not really in the fact that the families have been together since the 1970s, but instead in the romantic relationship or the marriage that he had with Mullar Krekar's daughter. So just to go through the very brief facts on this point. On the 11th of August 2011, Mr Amin marries in the United Kingdom. His marriage certificate is at page 323 of the bundle. and just to pad out the factual position, my lords will see that it's Miss Vora that he gets married to, ranked at the time, or the profession given is school administrator. The couple then have 4 children, which I'll refer to only by their initials, if I may. The first in time is MA1, who was born in June 2012, page 327 of the bundle. Second is MA2, they all have the same initials, born in May 2013, page 326. MA3 is then June 2016, 325. MA4, September 2018, 324. So we've got 4 children between 2012 and 2018. These relationships and these commitments that he now has, in my submission, really do bring an end to any concern that the Secretary of State may otherwise legitimately have had, that if this man is given his passport, if he's given a certificate naturalising him as a British citizen, that will clear him of his past troubles, whether it's the control orders which came to an end or were withdrawn ultimately in 2007, or the immigration issues, and he's about to go back to Norway or wherever this individual may be to reignite or to pursue this relationship.
That's not the point. It's not that he's going to reunite with the Krekar family. We know that's not going to happen because of the breakdown in relationships. The problem that you've got is the reasons why he wanted to associate with the Krekar family, the Secretary of State is in part concerned about, is that he identifies with or is comfortable with those views. And the question is there anything that demonstrates that the Secretary of State should disregard that now and assume that the views have changed? And the real question is, was the Secretary of State in error by saying the fact that he had a wife and 4 children was insufficient to demonstrate to her, the mere fact that he had a wife and 4 children, was insufficient to demonstrate to her that her concerns about association with extremists hadn't been overcome?
Well, my lord, first, just going back to the original point, the appellant's position, as we see in the witness statement that was annexed to the application for reconsideration, and my lord, this is begins at page 281, and paragraph 12 of that witness statement at page 283 refers to Mullar Krekar.
Yeah.
And expressly confirms that he did not share the extreme.
That's his views, yes. The Secretary of State doesn't agree.
Well, yes. And the family life point, and I'll come back to the views if I may, because it forms part of the third limb of my submission. Yeah. The family life point, I think it is appropriate at this stage to consider how it was that the High Court dealt with this point. And that
just before we look at that, I understand your submission that the marriage and 4 children is another important element of the background. I get that. It might be said that it puts it a bit high to say that brings an end to any concerns that the Secretary of State may have had. Plenty of terrorists are married and have children. I don't understand the connection. Simply because you're married, simply because you have children, does not mean, if there are concerns, that those concerns are allayed. Yeah. Surely.
Well, firstly, the Secretary of State's position, my lord, has not been, in the course of this litigation, to suggest that the appellant is a terrorist. The
distinction I understand that, but I'm just testing the proposition. Your proposition is this is a complete answer.
Yes. Well,
that the Secretary of State is irrational because she has not concluded that because Mr Amin is married and has 4 children, that must mean that he's a man of good character. And I'm just testing that because I'm afraid it doesn't follow. I mean, I can see it's a point you're quite entitled to make and rely on as part of the overall picture, but doesn't it put it too high to say, well, that brings an end to any concerns?
My Lord, with respect, I'd say it doesn't. If we look at the refusal letters in the round, and the High Court treats there as being four, one of those being the pre-action response, they all, but for the last one, which appears to really go much further than the first three, the earlier three refusal letters all do not dispute the origins of his relationship with the Krekar family as being that marriage. Now,
So I don't understand that. What are you saying? Say that again.
The Secretary of State doesn't appear to dispute in the refusal letters that the origins and the nature of the associations that the appellant has with the Krekar family were directly connected to that 3-month marriage.
Sure, that's
No,
right.
it's not.
in
This
fact.
is not true. Look at page 300. The very first paragraph, the third main one, says, due to your association with no members of the organisation and your relationship with Mullar Krekar, who was the leader, when you chose to travel from Sweden to Norway to visit him, which is what happened.
Yes.
He contacted Mullar Krekar, and he had no idea about the marriage then. In retrospect, he thinks that Mr Krekar might have had that in mind, but that wasn't his motivation. And then it goes on to deal with the fact that the families had known each other for some time. So I don't really think, this is the problem, they suggested that it was a romantic relationship for a year which went badly wrong, and that's the only concern, isn't it? You've got two families, one of whom has a member who is the head of a terrorist organisation. They've been close together for decades. There are at least 2 marriages within that, and you have your client, Mr Amin, contact him saying, I'm coming to Sweden, and Mr Krekar saying, why didn't you come a bit further, go to Norway and visit me as well? And he did. That's the concern. Not he got into a romantic relationship with somebody, unfortunate that somebody's father was a member of an extremist group. He contacted the family and Mr Krekar, and following that he got married. Not he contacted Mrs Krekar because he wanted to marry.
Well, my Lord, I'd invite the court to read the decisions differently. Yes, there is, and one has to accept as a matter of fact, the Secretary of State begins her refusal letter by making reference to the contact that Mr Amin initiates with Mullar Krekar, and of course setting out his background, and by that I make reference to Mr Krekar. But in reality, in my submission, the real concern that the Secretary of State seems to come back to is the fact that the appellant prolonged this relationship.
He wanted to stay a member of the family headed by a terrorist. Yeah, that's what she's saying.
Well,
He wanted to be part of that family, and when the marriage went wrong, he tried to keep the marriage alive, and he wanted to remain part of it. Indeed, he went back there for 8 days in June 2005.
Well, there's 2 points to that. One is, and I think this is reflected in the most recent of the refusal letters, we then have a prolonged period where there's been no contact. And the second point that I'd make is, ultimately, the evidence doesn't demonstrate that the appellant's intentions were directed towards remaining part of the family. It's all about the marriage. Now, as a matter of fact, being married to Mullar Krekar's wife means that he will be part of the family. That's
He'd be the son-in-law of the head of the terrorist
Yes.
organisation.
But the
He's happy with that and wants it.
the focus being on the relationship. Now, my lords, I think without
We've got your point, yeah.
without wishing to repeat the point, of course, I've said that the families must be.
And so he's married with 4 children, and you say, would you say that was ignored or overlooked, but you also say it could only lead to one conclusion?
Yes. Now, if I may then just revert back to my point on the High Court decision on this, and it's paragraph 18 of Richard Clayton QC's judgment at page 45 of the bundle. Now, my lords will see that the High Court's position, what is a relatively brief judgment, was that it was plain from the decision letters that the defendant had expressly considered factors that the claimant had raised, such as the new relationship in the UK, relationship with his wife and children, and the remote possibility of contact with Mr Krekar and his family. With the greatest of respect, the appellant's position is that is not borne out by any reading of the 4 refusal letters that we have.
There's no express references there to the children.
Or the wife.
In any of the letters, or the wife.
Or the wife. I mean,
Well, you do have to read what was said in the 2nd of April reconsideration letter. I have considered the information provided in your latest witness
But
statement.
just as a point of detail, there's no express reference to the family or children in any of the bundle of letters. Is there a reference in the pre-action protocol response letter to the family and the children?
my lady, from memory, no, but it may be
No?
wise
Right.
just to revisit
Thank you very
that
much.
point. So as
That's
to,
a point of detail.
Can I just object? You talk about the 4 letters. I've effectively, when you're down to 3, the
Yes.
14th of January 2019, the 2nd of April 2020, and the supplementary 22 February 2021. Which one are you including as the 4th?
My lord, purely for the sake of consistency, the High Court includes the pre-action response.
Or you
as
include
the
the,
fourth
yes,
letter.
although that isn't actually a
not a
decision.
decision,
Yeah.
yeah.
That's what you are referring to.
Yes, that's right. As I say, that's purely for the sake of consistency, but I do appreciate that.
So that's the one of the 30th of June 2020.
My lord, yes, that's 227.
So that makes up the quartet.
Yeah.
Yes.
But as my
It's
lord
not-
says, the letters are the 3 you've identified.
Absolutely.
You understand that?
And there is no head-on challenge to the pre-action response, and to do so would be improper.
But what do you say about the paragraph in the 2nd of April letter, which, don't forget, he asked for a reconsideration, he put the statement in, and there's one line, I think, that refers to the marriage and the children in that statement, and she said she's considered the information.
Well, my lord, I think the 2 points, starting off with the contents of the witness statement itself, its
Yeah.
brevity in my submission should not be taken as capable of detracting weight from the position that was put forward.
There's nothing, for example, say I've married a wife and I've got 4 children, I've moved away from my previous life, it's completely different. All we have is the reference to there being a wife and children. That's factually correct, isn't it?
Yes, it is.
The
my
witness
lord.
statement does refer to a wife and children.
Yes, and my lord, that's right. It's paragraph 9 of the witness statement.
I have remarried and have children in the United Kingdom.
But my lord, the position that the appellant would take is, well, if we look at that paragraph, he's dealing with his historic associations with the Krekar family. That same paragraph then goes on to say, I have remarried. Now, without abusively trying to add to that witness statement, in my submission, that reads as, my life's changed.
Right, okay, so...
That's the sentence on which you say, because of that sentence, not granting naturalisation was irrational, because that sentence brings to an end any concerns that the Secretary of State had. And as I say, speaking entirely for myself, I just think that puts it too high. I think it's an irrational submission. Of course it may be important, I understand that. To say, well, that's it, that's the answer, I can pack up and go home, it just strikes me as overdone.
My lord, I think 2 points to make to that. It's again, it's not the sentence, but it's the impact of that sentence. And secondly, as I say, it is a holistic consideration of all of the factors. I'm not inviting the court to find that I should get home.
You are. It brings to an end any concerns the Secretary of State might reasonably have had, you said.
Well, my lord,
So
yes.
that demonstrates the significance in your submissions of the sentence.
Well, my lord, I think that as I say, needs to be unpacked, just to go back into the context. Prolonged relationship, as the Secretary of State alleges, between the appellant and the Krekar family, linked to the marriage that he's had with the daughter that lasted for a short
I
period.
think the point is wanting to prolong, wanting to be part of, wishing to be associated with a terrorist family, and that doesn't work. That's the point, not the family. It's extremist views of the family and still wanting to be part of it. But there's a second problem you've got, although, as my lady correctly says, there's no express reference to the children and the wife. There is that one brief reference, and you said that brevity is not a problem, but at 247 in the decision, in the reconsideration letter, she says, I have considered the information provided in your latest witness statement. And then she gives reasons as to why she doesn't think it changes things.
Well, my lord...
that would have to be irrational as well.
My lord, yes. And in my submission, I was coming to that decision as part of my submissions. The reference to the witness statement in the 2nd of April 20 reconsideration letter does not, in my submission, demonstrate a proper consideration of the family ties that the appellant has alluded to in his witness statement, brief or otherwise they were. And if that paragraph spanning between 247 and 248 of the bundle is read in the round, the Secretary of State's focus appears to be solely on a question of the alleged discrepancies between what he said of the extent of his connections with the people that he lived with in the previous witness statements in comparison to what he's saying now.
Yeah, I understand that submission.
And with that, I think I can move on from that point. But ultimately, and I think just for the sake of going back to my lady's question on the pre-action response, I don't believe, having read it a number of times, that there is in fact any... The focus of that letter appears to continue to be on the associations as opposed to the circumstances in present day.
Yeah.
And the final point, just in respect of the association point, my lord, and this is with reference to the language that's used in the original refusal letter. Now, I fully accept that they have to be read in the round and together as the High Court correctly indicated in its judgment. But looking at page 300 and going on to 301, if the court could indulge me to read the final line of page 300 and then the first two lines of 301.
Yeah.
The difficulty that the appellant has with this element of the Secretary of State's decision is the penultimate word that's used. It's the fact that the relationship is treated by the Secretary of State as, to quote, is long-standing. Now that seems to be...
Is what, sorry?
It's the final... so what the Secretary of State does, my lord, is to say, accordingly, by your own admission, you initiated contact and associated with Krekar whilst aware of his background, and then goes on to say that the relationship between his family and the appellant's family is long-standing. Of course, the first point is not about the families. This is...
No, but it's the context. If families have known each other for a long time, it's much more likely they'll have spoken about the things that matter to them. If you've known somebody for 20 years and you've intermarried, bits of the family have married into families, you're much more likely to know that he doesn't work at Tesco's. He is, in fact, the head of an Islamic terrorist organisation. That's the point about long-standing. The context is many decades of these two families interacting. So any suggestion that he didn't know, or some might say even be unsympathetic to it, wouldn't be credible. It's not saying because you have had a long-standing relationship with somebody, you must be punished thereafter. It's the context in which you assess the knowledge and willingness of the applicant to participate in that kind of life. That's the point, I think, that the Secretary is trying to get home.
My lord, and I wouldn't seek to suggest that the issue of the question of fact about associations can be argued before you, given that Lord
So
Justice
what is
Hales,
the point about this sentence?
It's the fact that the relationship appears by the use of the word is to be treated as continuing.
Oh.
And as I say, it is important, going back to the language that's used in Schedule 1, to remember that this is an assessment of the appellant's character in present day. I'll leave that point there.
Without, this of course is the first
Yes,
decision, so this is pre the witness statement.
yes,
Yeah.
that's right.
Yeah.
My Lord, that brings me on to the third and final point that the appellant wishes to advance before this court, which really goes into the detail of the alleged associations and the alleged relation. Take out the word alleged, given the grant of permission, the associations that the Secretary of State relies upon. And again, just to emphasise, it is a holistic consideration that the Secretary of State was required to take part of. What we have is an individual who, whilst arrested in 2005, never been convicted. We have the Secretary of State relying on control orders.
Never been convicted of terrorist offences.
Yes.
He has been convicted of criminal offences.
There was certainly reference, I think, to the driving offences.
Yeah, I think two driving offences.
Yes, which are not relied upon, my Lord, for the purpose of the Secretary of State's refusal.
No.
But you can't say he's never been
You can't say he's never been convicted.
That's not right.
Forgive me. In the context of the discussions we're having today, as my Lord has said, for terrorist offences, which is the concern that the respondent continues to rely on, just stepping aside for a second.
But he's never been charged, I think, with terrorism offences.
No, I don't.
Even though not convicted, he wasn't charged.
No,
he was released without charge.
My Lord, yes. Now, we have the control orders that the Secretary of State says worked as a deterrent to the appellant having contact with the individuals that he lived with. Well, the first control order was successfully challenged on its terms in the High Court and
I
ultimately...
don't understand the reason for that. There were two. The second order wasn't challenged ever, but was withdrawn in 2008. The first order was successfully challenged and compensation was paid, presumably for unlawful detention. But I have no idea whether that's to do with the fact that there was something wrong with the assessment of Mr Amin, or whether it was the general, they applied to non-British people but didn't apply to British people.
I may have to come back to you on that, my Lord, but my reading of the appellant's witness statement was that what the High Court was troubled by was the terms of the order.
Yeah, but that doesn't tell us anything.
No.
We don't know whether it's personal to Mr Amin or whether it's some legal error on the part of the Secretary of State. And unless there's some sort of finding by the court that Mr Amin is an upstanding citizen and the Secretary of State couldn't even have begun to think a control order is appropriate, then it's hard to see how the fact of the control order first being set aside is relevant, and we just don't know. So to make the statement doesn't help a court.
No, my Lord. I don't
unless
make
more is provided, and it should already have been provided, if that's your point, I can't see that that's of any relevance.
No, my Lord. The reason I pitched that before the court is simply to remind it of the factual circumstances. And of course, there was a second control order, so that would negate the idea that the Secretary of State wasn't entitled.
Well, that's what makes me think that it's not personal to Mr Amin. It's to do with, well, I don't know whether it was a discrimination point. I don't even know if the order in Mr Amin's case was set aside by the court, or following the setting aside of some other order, that order was withdrawn. And you can't really rely on points unless they're relevant and unless we have the information.
Well, my Lord, this, if I can...
I mean, you referred to the control orders because you said, well, the Secretary of State said, well, there were control orders and they acted as a deterrent. So, yes.
And one of those, the final of those control orders, of course, was withdrawn some time ago.
2008.
And yet what we don't see is subsequent to the withdrawal order, the withdrawal of that control order, the appellant jumping back to the associations that he had with...
No, she says the initial restrictions stopped the communication, stopped the immediate contact, and what he's concerned with now is how that would impact his immigration status rather than whether or not he didn't have the views. And she says that's supported by the fact that he's distancing himself now in his recent statement and contradicting what he said earlier.
Well, my Lord, just going back to the sort of the list of points, and I appreciate my Lord's summary of the refusal letters in this case. I had, of course, planned to address you on the nature of the association, so what the Secretary of State...
Well, you need to do that because what he says in his latest statement appears not to be correct. He says that we need to separate them out. I mean, Mr Safadin, as I understand it, lived in the flat. It was there before Mr Amin moved in. And I apologise if I get the name wrong, but Mr Jutar was somebody who didn't live at the flat, but is one of the people who... as association with Mr Amin, the Secretary of State is concerned with. He knew Mr Amin well. He slept in the flat with Mr Amin. He was on the bed. I think Mr Amin was on the floor. He gave him advice because he was expert in Sharia law on the divorce. He did various things for Mr Jutar, like buy air tickets for third parties, bought scanned IDs and so on. So Mr Safadin, as I understand it, if I'm correct, and tell me if I'm wrong, he knew, spoke to frequently on the phone and held money for him. Mr Juttar, there were all the relationships that I mentioned, although he didn't live at the flat. And that doesn't seem to be all I did was sleep and eat there.
Well, my lord, on a prima facie reading of the most recent 2019 witness statement, one may conclude that there is one may reach the preliminary view that there is a discrepancy. But in my submission, there isn't. The statement from 2007 is significantly more detailed. It runs to some 40 or so pages, and it served a different purpose. But ultimately, they don't collide with each other. On one, he says, well, you know, the 2019 witness statement indicates that the appellant, as he says at paragraph 13 at 283, wasn't aware of their political views. That's not something that's contradicted in the earlier statement.
No, but look at 14. This is the point. It's not whether we think it or not, it's whether the Secretary of State was entitled to take the view that he's distancing himself now, rather than a change of view. And what he says is, all I did, whilst at the property, was sleep on the floor in the living room and eat occasionally. On any analysis, that contradicts the evidence. I had regular telephone contact with Mr. Stafford. He'd often ask me to do things for the house, and I would do them, and then he'd call me for the jobs to see that I'd done them. I don't see how you can say there's not a discrepancy there. He didn't just sleep on the floor and eat.
Given that my lord disagrees with me on that point,
But is it correct? Because the point is, if the Secretary of State is entitled to take the view that this is inaccurate and is distancing, then she's entitled to take the view that that's relevant to her overall assessment, isn't it? So if that isn't correct, there's a problem. And if the other bit, I only wanted to find out why Mullar Krekar's daughter wanted a divorce, isn't correct, because he spent days trying to change her mind. Aren't those factors that the Secretary of State could take into account in saying, has he changed his views and now he's trying to distance himself, or not? Aren't those matters she can look at?
The appellant's initial position would be that there isn't a discrepancy because one statement is clearly far briefer in its nature. The statement from 2007...
Well, that's the point.
Okay.
I mean, I think it is much briefer, which is quite telling, because the statement, the 40 pages in April 2007 is very detailed.
Yes, my lord, and I think...
And details the relationships and the sorts of things they talked about.
Well, my lord, the point I'd make in direct answer to your point is that you have a much more detailed statement, which does indicate, as the Secretary of State says in her refusal letters, is that there were financial and personal connections between the appellant and the individuals. The discrepancy that the court identifies is not one that in my submission is material, because even on the more detailed witness statement, there is nothing which shows the appellant to have held those extremist views. It explains each and every one of those associations, whether it's the phone calls that appear to have been a concern, whether it's the financial transactions, or just the mere associations themselves, by reference to an innocent explanation.
All right,
That
so,
is where
the submission comes to this, that if, to the extent that there are discrepancies, they don't go to what you say is the central point about the views held.
My lord, yes.
Can you sign that?
The final 2 points that I seek to make before, of course, seeking to hand over to my learned friend, would be, firstly, the evolution of these refusal letters. Now, the initial two, excluding the pre-action response, are confined to the appellant associating with others who hold extremist views. The most recent, then the appellant would say, without any real backing, changes the position. We don't have a moving of the goalposts. The appellant would say that the goalposts have been changed for a basketball net in the course of these proceedings, because we go from mere association with people, we go from association with people with extremist views to it being suggested that the appellant held these views himself. Now, reminding ourselves of the context, the passage of time, the relationship, lack of charge insofar as terrorist offences are concerned, the lack of any convictions with regards to terrorism offences, this change of course is, in my submission, a further factor which demonstrates that the appellant, the refusals in this case, are ultimately irrational.
And just to elaborate, the change of course is what the Secretary of State never suggested he had these views and now suggests he does have the views.
Well,
no, just so that I understand physically, so I write down the right thing.
Yes, my lord. The crux of it is that there was a very defined position that the respondent was taking in January 2019 and April 2020, and it was limited to his associations with others who held these views. That morphs into a completely different allegation come 2021, and it isn't, in my submission, even with inference, supported by the evidence that the respondent had been furnished with.
She hedges her bets, one might say, for example, page 301, in the middle, due to the close proximity you shared with some of these individuals and the length of time of the association, and the absence of evidence to the contrary, there is no reason to conclude that you were unaware of their views. That's presumably unobjectionable. Notwithstanding this, you continued with these associations, so he continued to associate both with Mr Krekar and these individuals, knowing of their views, and there's no evidence to suggest that you were seeking to counter or moderate their extremist views. Stops short of saying, and we think you shared them, or at least
Well, precisely my point.
proved
Does,
them.
yes.
And you say that's the point.
Yes.
And then later on she says, I think you had them too. Is that in the February...
It's the... I think it's page
78, the second paragraph at the very end. There's no evidence that the views held by these individuals were or are not views held by yourself. She now does say she's linking the two expressly. And what do you say is the consequence of that?
Well, my lord, if that is the Secretary of State's true position, as is crystallised in the final refusal letter, there is no evidence to support that position.
Well, no, it's an inference.
To support that
You're not going to write and say, yes, I did have those extremist views.
Yes.
She's got to infer it by definition.
Yes.
And she's saying, I infer it from all the matters that we've discussed already. And is she entitled to infer that?
Well, the appellant would, in short, my lord, the appellant would say no, given
No,
the
I know he says she shouldn't have, because I don't have those views. But as a matter of law, would it be irrational for the Secretary of State to say, look at all of this?
On the facts, the appellant would say yes, my lord.
It is irrational to
Yes.
conclude that he had those views.
My lord, yes.
And is that in your grounds, out of curiosity?
Not with reference to this change. This change, of course, comes about post the judicial review claim having been initiated.
Yes, but pre the last hearing, and certainly pre this one.
Yes, no, the short answer is it's not in the grounds.
No.
If I can then move on to my
Hold on,
final point.
so it's not part of the grounds. I haven't missed it in the skeleton or something, have I?
No, my lord, I don't believe you have. But my lord, of course,
This is public law. With great respect to my lord, anything goes. People's positions evolve the entire time. Nailing your colours to the mast is not something well known in the administrative court.
But there is a counter-revolutionary move headed by the Lord Chief Justice and numerous other public law justices of appeal that are saying you should do that, and the battle has not yet been concluded.
I would love, personally, to see that happen. Anyway, there it is. So that was that the penultimate point?
It was, and my final point really comes back to that discussion that my Lord Justice Lewis and I had in terms of what more could the appellant have done. And I just want to end on a comparison, and this goes back to the authorities bundle and the respondent's guidance. And it's page 185 that I'd invite the court to turn up.
Page 185 of the authorities.
My Lord,
Yeah.
now, my Lord, please bear with me whilst I muddle through this point, but what you have at the bottom of that page is a subheading, unacceptable behaviour. That, again, carries with it a discretion that an individual who has engaged in unacceptable behaviour will normally be refused British citizenship, but then it provides some guidance as to what would be required, of course genuinely, in order for the Secretary of State to grant citizenship. And it talks about publicly retracting their views and not re-engaging in such behaviour. The definition, or not so much the definition, but the guidance that's given as to unacceptable behaviour refers to positive acts. We have effectively, as you'll see there from the bottom of page 185, references to websites, publishing, and then also effectively what one could say is an abuse of a position of responsibility, such as being a teacher or community leader. Moving on to 186, to incite, justify or glorify violence. Now, without wishing to minimise the seriousness of what Mr Krekar has been involved in, there is in my submission...
Well, he's currently in prison in Italy, as I understand it,
yes.
for terrorist offences.
Yes, I think he was extradited. My Lord, that's right, and Mr Malek's skeleton argument refers to that in paragraph 4.
Yeah.
What's defined as unacceptable behaviour is, in my submission, not only a positive act, but something which arguably is far more serious than what the appellant has been accused of. And yet what you have here is a far, in my submission, more lenient position that the Secretary of State takes with regards to...
well, that's a matter for her. It's for her to decide what's good character, whether somebody should get it.
Well,
if she's satisfied that somebody who makes a public recantation is suitable, that's for her. If she says you're associated with terrorist people, and I believe you share their views, and I haven't seen anything to contradict that, she's justified to do that as well, isn't she? We're not the Secretary of State.
No, my Lord. And this is why I think one must get to the ultimate comparison, which is that ultimately these decisions are, of course, as we know, susceptible to public law review on ordinary public law ground. Ultimately, the question my Lord asked was, well, the question I think I asked in a rhetoric fashion is, what more could the appellant have done? In my submission, for lesser conduct, the appellant has done far more than what the guidance requires for unacceptable behaviour, which is simply a public retraction and not re-engaging in that behaviour. Well, he hasn't re-engaged in that behaviour. There's no associations, as the Secretary of State appears to accept, for the last decade and a half. And on the facts that you have before you, and this comes back full circle to the beginning of my submissions, present day, there is nothing to suggest that this appellant will ever re-establish those associations with either Mr Krekar, his family, or the individuals that were the subject of the control orders.
But the question is, what evidence are you showing us, if we don't accept your submission, that the Secretary of State was entitled to take the view that he had the same views or similar views? Where's the evidence to show that he's changed those views?
Well, it comes back to that headline point, my Lord, that I made about the appellant, that there being an effective new direction and chapter in his life.
The only evidence that he's changed his views, as opposed to not going to see the Krekars anymore, the only evidence that you're relying on we change your views is the marriage and children.
Passage of time, marriage, the relationship that he has, you connected to that marriage with someone who, as I said, was a school administrator, now a teacher. The children, and this just has not been grappled with. Even taking into account what was said in the 2nd of April 20 refusal letter and reconsideration decision about the reference to the witness statement, this just has not been grappled with.
Those are the two things, passage of time and the marriage and children.
Yes, and I made brief references to the university and
Oh, yes.
and the rehabilitation point that he makes. Yes, and my lord is of course aware of the position that I've made in respect of not being charged or convicted of terrorism.
No, he's never been charged. No.
And
He
so
was released, he was never prosecuted. It wasn't that he was not acquitted, the state didn't think he'd done anything.
no, my lord. So when that's taken into account, whilst I accept that the authorities really do limit the shooting target that the appellant has to reach, the appellant would say that when all of these factors are taken holistically, the time, the relationship, the lack of any identification of the appellant being a risk to the public, which of course must be an underlying factor when it comes to the concerns that the Secretary of State has. It may be one factor, there may be others that arise.
If he was a risk, he wouldn't be of good character, but that's not the definition of good character.
No, but it is, in my submission, my lord, it is relevant with regards to the holistic consideration. The appellant would invite the court to find that despite the narrow basis that you have to undermine the Secretary of State's decision and to grant relief, the appellant has made out his case. With that in mind, if I can briefly look over my shoulder. My lord, unless I can assist any further, my lady, I'm grateful.
Thank you very much. Mr Malik, just before you start, we'll just rise and take stock.
I'll rise.
Mr. Malik, unless there are 2 points that we want to hear you on, plus anything else that you're so desperate to say that you can't allow the hearing to go by without saying it. But other than that, there are only 2 points that we want to hear you on. One is whether you have any submissions to make about AHN, and in particular paragraph 29 of that, which is obviously not helped by the fact that in the middle of it there appears to be something that makes no sense. But are there any submissions you want to make about AHN?
Simply to say this, that if the proposition is that the passage of time is a relevant consideration, that is not controversial. But I do not understand Mullar and Friend to be arguing that it is determinative.
Yeah. So you accept it's a relevant consideration. Yeah, you don't accept and you don't understand it to be an issue that it's determinative in this case. No. All right. Thank you very much. The second issue that we would just like a bit of assistance on is that it's suggested that there has been a certain amount of moving of the goalposts certainly between the first 2 letters, to the one of January 2019 and April 2020 on the one hand, and then the more recent one of February 2021. Is there anything you'd like to say about that?
I would accept that things evolved. The reason for that, Lord's Milady, was that after the first decision, the appellant adduced further evidence, made a witness statement, which was then considered. The appellant then issued a judicial review claim, focusing on the passage of time point, and made certain new arguments that led to a further consideration, and that resulted in the supplementary decision letter. The appellant had all the opportunity to challenge the decisions. In fact, he did, and it's uncontroversial that it is appropriate to read all 4 decisions together and then decide whether...
There's 3 decisions. The PAP is not a decision, I'm sorry.
But what was being said by Mr Krekar was A, change of position, but B, that the position taken in that second letter, third letter, was not backed by any evidence, so no evidence to support the change position. What's your nutshell response to that?
So the position that the appellant may also have extremist views. The fundamental difficulty for the appellant in my respective submission arises from the witness statement that he made to the Secretary of State. You have that witness statement in the bundle.
Which one dated? Which one are you referring to?
This is the statement dated 26th of August 2019.
Right, 2019 statement, yes.
Page 281 of the bundle. Mm-hmm. Now, may I respectfully take Lady and Lords to that witness statement, just to assist the board with it. Now, you'll see that at paragraph 11, this is page 283, the appellant says that, he never knew or cared for any of his or his family's political views, and then makes the point that he does not agree with those views. And then paragraph 16, I did not have any association with them. So he was positively distancing himself from the associations. Now, the difficulty in my respectful submission is that he has not provided details of the views that he holds. It's not enough for him to say that I disagree with Mullar Krekar's views. He may have views that are more radical than Mullar Krekar's views, or he may have extreme views without realizing that those views are extreme. Now, in that context, in absence of any detail in my respectful submission, the Secretary of State was perfectly entitled to express a doubt and to say that that is a reason, or one of the reasons when considered in the context as to why the appellant is not of good character.
Can I just check what the position is? Because there are lots of gradations. She has to be satisfied that he is of good character. Is she saying long association with a family headed by a terrorist member and all these other things, I think he's got the same views too? Or is she's saying, I can't be sure about that, he's never said his views? Or is she saying, I don't believe what he's saying, because what he's saying in this statement is far less about the associations he said before, and what he's trying to do is distance himself? Which is it?
I think it is the last one.
The last one.
And
Trying to distance himself from the views.
Yes.
They're from the people.
It's common ground, isn't it, that she had to be satisfied on a balance of probabilities. Yeah.
And she's entitled, because he's trying to distance himself, to infer what? That he had the views and there's been no real change in views.
Yes. Or that the association ended not because of the free will, not because he decided to end the association, but because of the matters that were outside his control, such as the breakdown of the marriage.
Yeah. In a sense, that wouldn't matter, because if the association had gone and there's nothing else to worry about, then it's over. It's only if it's the views coming out of the association, if they can be attributable to him in the absence of evidence that that's changed, that there's a proper basis for the Secretary of State. So is she inferring, or is she not inferring, that he had views that were unacceptable because of the people he was mixing with, and she hasn't got evidence that they have changed?
Well, she is that is in my respectful submission what she says towards the end of the third letter. Yeah. And the reason why in my respectful submission the letter is framed or formulated in this manner is because of the very limited information that the appellant chose to provide in his witness statement.
The limited information about his views, you're saying, or limited information generally?
Limited information about his views and generally as well. So you have, it's just one particular paragraph about that I have remarried and I have children. No explanation as to the nature of the relationship, whether he actually has a subsisting relationship with the children and how they have changed or moderated his views.
All right. Well, those were the 2 points we wanted to ask you about. But as I say, if there was anything else, obviously we've read the skeletons, we understand the points in the exchanges with Mr Krekar. We, I think, made it clear what we think the important points are. But is there anything else, Mr Malik, that, as I say, you have a sleepless night if you didn't address us on?
Perhaps one point which is not dealt with in the pleadings and the skeletons. And Mullar Krekar, towards the end of his submissions, took you to page 185 of the authorities bundle. This is the guidance on the unacceptable.
Oh, right, this is the comparison point.
Yes.
Yeah.
Oh, yeah.
Yeah.
So if you look at page 185, you'll see that the passage that Mullar Krekar has highlighted falls under the heading extremism, unacceptable behavior. But that is different from what appears at page 186 and 187. So there is a separate, distinct part in the guidance that deals with the associations, and which is at pages 186 to 187. the part that Mullar and friend has highlighted on analysis, in my respectful submission, is not directly applicable in this case.
I don't think he's suggesting otherwise. He's just saying, in answer, in the context of the hypothetical question, what more could Mr Amin have done, is saying he's done more than would have been required under the policy guidance for what could be seen as more serious behaviour. That was his point, I think.
Yes, and I respectfully adopt everything that Lord Lewis said on that point when Mullar and friend was making his submissions as to what the appellant could have done. The least that he could have done was to set out in the evidence as to what his views are. So unless there are any particular questions in the light of what the court has said, I do not propose.
No. Thank you very much, Mr. Malik. That's very helpful. Mr. Krekar, is there anything else you want to say in answer to any of those 3 points that Mr. Malik's made?
Not unless I can give any explicit assistance, my lord.
Sorry,
Not
so-
unless I can assist you.
No, I think that's fine. All right. Well, thank you both very much. We will produce our judgments, I think, relatively speedily. You may even have them next week, but I'm not promising that, but you may do. You'll get them in draft. That's obviously an opportunity to correct our spelling and our grammar, but not an opportunity to re-argue the case. We are encouraged to say this, so I will say it. You will get it under an embargo in the usual way, and as you probably both know, as a result of recent excitements, the embargo is very important and must be adhered to on pain of death. All right? All right. Thank you both very much.